Everybody, thanks for coming out this morning. Today we appeared in Courtenay Provincial Court and filed a notice of constitutional question on behalf of Mr. Yacub, who is charged with violating the Controlled Drugs and Substances Act by providing marijuana for medical purposes to members of the North Island Compassion Club. Mr. Yacub is challenging the constitutionality of the Controlled Drugs and Substances Act and the marijuana medical access regulations promulgated under that act on the basis that that scheme, enacted by the federal government more than 10 years ago, fails to provide lawful, adequate access to both the legal protections of the scheme, in other words, people's ability to become free from criminal prosecution for their medical marijuana use, and because it also fails to provide patients with a safe, effective, and lawful source of cannabis and cannabis-based medical products. This is a federal government program that has been found to be unconstitutional on several occasions in the past, including here in the BC Supreme Court on 2 occasions. And we fully expect to demonstrate to the provincial court here in Courtenay that the system the federal government has set up continues to be ineffective, continues to deny patients the ability to access this safe and effective natural health product. And we hope that a successful result in this case will finally drive home to the Harper Conservative government that Canadians, critically and chronically ill Canadians, deserve safe, unfettered access to medical marijuana to treat their serious symptoms and conditions. At that, we'll open it up to any questions you might have.
Do you think it's kind of, what was the court's reaction? Are they prepared locally to deal with this, or is it kind of like out of their realm?
Well, I think the court, of course, is prepared to hear the case. The administrative law judge's reaction this morning upon being told that we would require a minimum of 10 days to make the charter arguments was to advise us essentially that there are a lot of cases in the courts. As any Canadian knows, the courts are facing an extreme backlog. There are very serious issues being heard by the courts, child custody issues, issues involving victimization of children, issues involving very serious crimes. And I think the court's reaction was along the lines of, if this is going to take a lot of time and push those other cases back, there was a bit of frustration expressed about that. And certainly Mr. Yacub shares that frustration. I mean, I think we always need to remember that it's the Crown that decides whether or not to prosecute these cases. The Crown has discretion not to bring charges if it comes to the considered conclusion that it's not in the public interest to bring charges. And I would say, based on this medical marijuana program being found unconstitutional repeatedly in the courts in multiple provinces, in multiple decisions over 10 years, that I personally, as a taxpayer, can't understand why limited Crown, judicial, and law enforcement resources are being expended going after medical marijuana patients and those compassionate people like Mr. Yacub who provide them with a safe and effective source of medicine.
So you mentioned that there have been challenges to these laws in the past. Have they been successful, I take it? I mean, have these laws been, what is the highest level these laws have been challenged at? And what exactly, are you seeking to take this to the Supreme Court if necessary?
We're certainly prepared to go to the Supreme Court of Canada if necessary. At this juncture, the Supreme Court of Canada has not granted leave to a medical marijuana access case. And so the highest level of court in which aspects of the federal government scheme have been found unconstitutional is the Provincial Court of Appeal in Ontario. These matters have been litigated extensively in the trial and appellate courts in Ontario and in British Columbia. And there's a couple cases on the way to both the BC Supreme Court and the BC Court of Appeal after that here in British Columbia. Now, of course, the federal government has also signaled its intentions to completely revamp the medical marijuana program in this country. Unfortunately, it's my considered opinion, and I think that's shared by medical marijuana patients across the country, that the changes being proposed simply aren't going to be good enough, and the program is going to continue to be overly restrictive and unnecessarily restrictive. Look, let's be very clear. Marijuana is a safe and effective natural health product. There is no reported case of overdose in thousands of years of human history. It provides little danger to patients who consume it and a great deal of benefit. In fact, it's one of the most promising areas of medical research going today. And so it is a bit of, you feel like you're living in a bit of a prohibition-based environment when sick and suffering Canadians are denied access to this safe health product in the name of a greater marijuana prohibition that itself is dangerous and ineffective.
We could just get a word from Ernie. You were operating really without anyone bothering you for a few years, and then you were raided. Can you just sort of take us back to those days? And you were really, you weren't bothered for many years, right?
That's right. We moved the dispensary from the train station about 7 years ago into my home and opened a dispensary, and we informed the police that we were opening a dispensary there, and we did that for 7 years without any trouble from the police whatsoever. They didn't come to talk to us, check us out, ask us anything, even to find out what was going on for 7 years.
And then you were raided, and what was the charge back then?
We were raided in February of last year the first time, and and we weren't charged. I wasn't charged until this year. We were raided again in July. Was it July? Yeah, July of last year as well, the second time. And after that, we had to shut the dispensary down because we couldn't afford to keep losing money and medicine. We lost quite a bit the first time around, and not quite as much the second time around, and it's taken us a while to bounce back. But yeah, so it was difficult. It was a difficult time, and now we're being charged. I'm being charged with possession for the purpose of trafficking.
And those are 2 counts, I believe you're facing.
2 counts,
And
yes.
you pled not guilty to both those counts.
We haven't pled yet.
We have entered pleas of not guilty to both counts in order to proceed to the constitutional question.
Perhaps I could ask you to detail what the allegations are for those of us who are not familiar, and could you clarify, are you disputing any of the alleged facts relating to the charges? Can you give me an idea?
Yeah, well, I don't want to get into trial strategy. The allegations are that Mr. Yacub unlawfully possessed cannabis for the purposes of trafficking it. Our response is that the members of the North Island Compassion Club are medical cannabis consumers that have serious medical conditions for which cannabis provides relief, and that they're entitled under the charter to possess that medicine, and they're entitled to a safe and effective source of that medicine, which was the North Island Compassion Club prior to it being raided. The really unfortunate part is that many of the members of the club have now been forced to go either without medicine or to go to black market sources, street sources of medicine of uncertain quality, purity, and potency when they had a safe and effective source right there at the North Island Compassion Club. So this
And a cheaper source. Because it's expensive on the street.
Yeah, and these raids and these charges have impacted the community in a very negative way, and will continue to impact the community in a negative way until the federal government comes to its senses and puts into place a system of access to medical marijuana that actually works and is actually to the benefit of the patients.
So, as I understand it, does the Compassion Club still exist? Or
yes.
It still exists. And was it licensed to be a distributor?
No, the only legal way that anybody can use cannabis or have it in their possession is by getting a license through the federal government. And there are three licenses. One is a license to possess, the other is a license to grow, and the other is a license to designate someone to grow. And the only way you can buy it is through Prairie Plant Systems, which has one particular strain. They grind it up and they irradiate it, and what I understand is that it's shitty pot.
Yeah, it's one of the allegations in the case is that Health Canada has been urged by patients and by managers of compassion clubs for more than a decade, and really before they put their program into place, to license compassion clubs, to regulate compassion clubs. And the unfortunate thing is, on the one hand, you have the federal government saying, well, these are illegal, unregulated businesses, while on the other hand, absolutely and categorically refusing to license them and to regulate them, which is what I think all managers of compassion clubs and all patients of compassion clubs would welcome. They would welcome the federal government putting into place a sensible set of regulations for these specialized pharmacies, and that's really what they are. They're specialized pharmacies dealing in cannabis-based medicines, and there's no reason, absolutely no reason at all, that they should be forced underground by our prohibition-based laws.
Why now? Why Ernie? Why did you decide at this point to go with this challenge?
Well, we didn't decide. They decided to charge me a year after or a year and a half after the first bust, and a year after the second bust. And our defense is that this is legal. This is a legal medicine that some people can have, but very few people can access, and that's the problem. The difficulty is, first of all, people can't get a license because they have to get their physician to sign a document. Physicians are massively boycotting the program. This is Judge Taliano in the Ontario Superior Court case. In his decision in Murnaugh, basically said Murnaugh has a constitutional right to his medicine. He cannot get it. He cannot get a doctor to sign the papers, and therefore either the law has to be changed or the medical marijuana program has to be fixed because it's not working. He said that doctors are massively boycotting the program.
Finally, for me, I'm just wondering how you feel then to be at the face going forward on a national level fighting this national
Well,
issue.
I'm just one more in a number of cases, and it's just what's been landed in my lap. Just like the club was landed in my lap. This was not a career move for me to run a compassion club. You know, I don't make any money on this. I do it because it needs to be done, and so I welcome the opportunity to inform people that the law is broken. It's wrong. People have a right to this medicine, which does all kinds of amazing, wonderful things for people, and it's a plant. You know, I mean, that's all it is. It's a wonderful, beautiful plant.
Just a quick question from me, just so I'm clear. Did you apply for a license and were rejected for a license?
No,
or you didn't apply.
No, there's no such thing.
No...
Oh, sorry. Personally?
Sure.
Oh, personally, yes. I couldn't get my doctor of 20 years to sign my papers, so I had to go down to Duncan to paid $150 to get a doctor down there to sign my papers in order to get a license, and that's in process.
And that's a license to possess marijuana for personal medical purposes. There is no application process for a compassion club to go through to become licensed by the federal government. That does not exist. It's something the federal government's been asked to do many, many times, and they just have chosen not to do so, despite numerous court decisions really underscoring the need for the federal government to do so. And just to be clear about something, you know, these are battles that aren't chosen by the accused. These are battles that are chosen by Crown. At any point in these proceedings, Crown Counsel can enter a stay of proceedings and discontinue the prosecution at any point in these proceedings. And indeed, they had the discretion not to bring charges against Mr. Yacub in the first place. And it appeared to be something that they were thinking about, at least, because a year went by between the most recent search warrant execution and arrest of Mr. Yacub and the actual filing of charges. And that's quite unusual. That's a quite unusual delay. And so it looked for a time that Crown had come to its senses, had declined to waste taxpayer funds prosecuting Mr. Yacub, and of course they could discontinue it anytime they want to.
Just so I'm clear, when was Mr. Yacub formally charged?
In July of this year. No, it was. When was it actually? It was about
a couple months ago.
It was about 3 months ago. Okay. Yeah. About a year after the actual arrest.
Just one more thing. There's people think that it's just about smoking cannabis. What they also got at our dispensary was they got cookies, and they got oil, and they got hash. And the point about that is that different people depending on their ailment, they depend on different kinds of cannabis medicine. For instance, myself, I rarely smoke it anymore. I've been smoking it since the 60s. I rarely smoke it anymore. I eat cookies because that's what helps my sciatic pain. That's what works for me. And so just to disabuse people that this is about smoking pot, it's not just about smoking medicine, it's also about vaporizing medicine, That's another thing. People have a thing about problems with smoking the smoke. People can vaporize it, and they can eat it. They can use it topically with oils, and those are the kinds of things that we provided at the dispensary, and we still do as a compassion.